Good morning. Yet another complicated issue because of the present scenario. Almost all persons used to purchase vehicle property by hypothecating the said property with the bank, and Surpass Act, DRT interventions attaches the property. So under that circumstances, a woman wife who was obtained, who was granted maintenance, a lump sum that which was subsequently not paid, and by filing EP if the property is attached, and that property was already attached by bank or other proceedings was initiated, it is what to do, what not to do is the most important question of law and facts. Our Justice R. Pongayappan seems to have intervened with a well-considered judgment. AR 2021, Madras 226, Gayatri Jayaraman versus V. Muthu. Transfer of Property Act, Section 39, Madras High Court, Original Side Rules 1956, Order 14, Rule 8. Transfer where third party is entitled to maintenance, attachment of property, failure of husband to pay agreed amount of dissolution of marriage by mutual consent, property of husband encumbered in favor of bank, wife being third party has right to receive maintenance from her husband by attaching property owned by him. It is necessary to create charge over the property. Order of conditional attachment passed against suit scheduled property. This is what see, the Transfer of Property Act deals with inter vivos. Inter vivos means among living persons. The person includes company, firm, and other things are there. They are considered to be living persons. But except charge, but what all are the transfer of property? Sale, exchange, lease, mortgage, gift, etc. all are the transfer of property inter vivos. But charge means by legal process. If suppose somebody not paid money, degree money, then the court may attach that property. That is called the charge. The transfer of property says all the powers, liabilities, duties, rights available for mortgage is also will apply to charge. That is charge. So that's what they say. The judge, the facts of the case, you may go through that. It's very clear. And finally, by reading Section 39 of Transfer of Property Act comes to play a vital role. Transfer where third person is entitled to maintenance, where a third person has a right to receive maintenance, or a provision for advancement or marriage from the proof of its from the profits of movable property, and such property is transferred, the right may be enforced against transferee if he has notice, or if the transfer is gratuitous, but not against the transferee for consideration and without notice of right nor against such property in his hands. So this must be deeply looked into. The High Court has allowed original application and tagged the charge attachment of property, which was already under the process of Indian Bank under a Surpass Act. So most important case, kindly go through this judgment. Then I have another case, a most important case for long years. The courts used to say that so far 304A, causing death by rash and negligent acts, are considered. The court said that there should be a sentence. But fortunately, Supreme Court AR 2021 3197, Surendra versus Sub Inspector of Police, they say the incident taken place for more than 26 years ago Accused was thrown out on bail. Trial court recorded conviction after marshalling evidence on record. Considering time gap, sentence of imprisonment under section 279 and 338 substituted by fine of rupees 1000 each, whereas sentence of fine under 337 is maintained. So some leniency they have given for these sort of offences since long years have run away. So kindly take this judgment also on your file, so that this by citing the judgment you may request the court to convert the sentence into fine. Best wishes, Surendra versus Sub Inspector of Police. This is Supreme Court judgment. Okay. Best wishes.